The morning my husband handed me divorce papers, he was smiling. Not the smile I fell in love with 7 years ago, that crooked, boyish grin he'd flash whenever he burned dinner or forgot our anniversary. This was something different, practiced, cold, the kind of smile that told me he'd been rehearsing this moment for a long time, probably in front of a mirror, probably while I was asleep in the next room. I had my attorney draw these up, he said, sliding a manila envelope across the kitchen island. You should look them over. I didn't reach for it. My coffee was still hot. I remember that detail clearly. The steam curling up from the mug my mother had given me the Christmas before she passed. I just held it with both hands and looked at him. Nathan, I said. What is this? It wasn't even a question. I think I already knew. He pulled out a stool, sat down across from me like we were about to discuss grocery lists, and explained very calmly that he'd been seeing someone, that things had run their course between us, that he thought it was best to be transparent rather than drag things out. Transparent. He used that word. My husband, who had apparently spent the last 14 months lying to my face every single morning, used the word transparent. I set down my coffee. I picked up the envelope. The papers were clean, professional, thorough. Everything itemized. The house, the joint savings, his 401k. My name was on nothing that mattered. According to the terms Nathan's attorney had drafted, I would walk away with my personal belongings, my car, a 6-year-old Civic with a cracked dashboard, and a one-time payment of $8,000. $8,000. After 7 years, you'll want to get your own lawyer to review it, he said, already scrolling through his phone. But I think you'll find the terms are fair. I looked up from the papers. Fair, Lenora. He said my name the way you'd say the name of a child who keeps asking why the sky is blue. You haven't worked in 2 years. You don't have savings of your own. I'm not trying to be cruel, I'm trying to make this easy. I didn't say anything. I folded the papers back into the envelope, stood up, and carried my coffee to the window. Outside, our neighbor was walking her golden retriever. 2 kids were waiting at the bus stop. Everything looked completely ordinary. I'll need you out by the end of the month, Nathan said. Stephanie is, he stopped himself. I just think it'll be easier for everyone. Stephanie. So that was her name. I took one more sip of coffee. Then I set the mug down on the windowsill, gently, because it was my mother's, and I said, okay. He looked almost disappointed. Like he'd expected tears, a scene, something to confirm that I was exactly who he decided I was, a woman with no options, no resources, no plan. He had no idea. Here's what Nathan knew about me. I had a degree in art history that I never used, a part-time job at a nonprofit that I'd left in 2024 to help care for his mother after her hip surgery, and no salary for the past 2 years. He knew I drove a Civic. He knew I clipped coupons and bought store-brand cereal, and that I'd been stressed about our finances since he'd moved most of our accounts into his name, for tax purposes. His words, 18 months before. Here's what Nathan did not know. I had passed the bar exam in the state of Tennessee at 26 years old. I had worked for 3 years as a junior associate at a civil litigation firm before I met him. I had left that career because he'd asked me to. Because he said his income was more than enough. Because he said he wanted a partner, not a colleague. And I was young and in love, and I believed him. I had not renewed my license, but I had never, not once, forgotten how any of it worked. I called my friend Jonah that same afternoon. He was one of the few people I'd kept from my old life at the firm. He'd made partner 2 years ago and specialized in family law. We met for coffee at a diner off Highway 70, and I slid the envelope across the table to him the same way Nathan had slid it to me. Jonah read it slowly. His face didn't change much. Jonah never let his face change much in professional settings, which was one of the things that made him very good at his job. He's lowballing you, he said when he finished. The house alone has appreciated over $300,000 since you bought it. Your unpaid labor supporting his mother during recovery has legal value in Tennessee, and this clause here, He tapped a paragraph near the bottom, essentially waives your right to any future claims on the business income. The landscaping company, I said, which did how much last year? Around 400,000 gross. Jonah set the papers down. Lenora, you need an attorney. I know. I can refer you to someone who does this full time. She's good, she's thorough, she won't let him. Jonah. I looked at him. I passed the Tennessee bar. A pause. That was 8 years ago, he said. I know the statute of limitations on what I know. He was quiet for a moment. Then he pushed the papers back across the table. You're going to represent yourself. I'm going to represent myself. He leaned back in his chair and looked at me for a long moment. You know he has Douglas Mercer. Douglas Mercer. Nathan's attorney. I'd met him once at a firm holiday party 3 years ago. Expensive suit, Harvard crest on his cufflinks, the handshake of a man who had never once in his adult life been told no. I know, I said. Jonah exhaled slowly. Then you'd better be ready. I had 6 weeks. I didn't sleep much during those 6 weeks. I drank too much coffee and not enough water, and I spent most nights at my kitchen table. The apartment I'd rented with the last of my personal savings, a 1-bedroom in East Nashville that smelled faintly of someone else's laundry, going through documents. Nathan's business records, which I had quietly photographed over the previous year because something had been nagging at me. Some accounting instinct I couldn't explain. I'd noticed things. The income that didn't quite match the deposits. The consulting fees paid to an LLC I didn't recognize. Small things, but I'd spent 3 years at a litigation firm learning that small things were usually not small. I filed my response to the divorce petition myself. I motioned for financial disclosure, I submitted a valuation request on the house and the business, and I showed up to every preliminary hearing in the same gray blazer I'd worn for every court appearance when I was 26, which still fit, barely, because I'd been stress-eating cereal for 6 weeks. Nathan's attorney, Douglas Mercer, Harvard cufflinks, did not take me seriously. Not at the first hearing when he spoke over me twice and the judge didn't stop him. Not at the second when he referred to me as the petitioner's wife, even though I had a name and it was on every document in the room. Not when he called a brief recess and I overheard him tell Nathan just loud enough, she doesn't know what she's doing. This'll be over in a day. Nathan laughed. They both laughed. I wrote down 3 words in my notepad. Remember this moment. The trial was set for a Thursday in March. I got there early. I always got everywhere early when it mattered. Old habit from the firm, where showing up late was considered a confession of unpreparedness. I set up my materials at the respondent's table, organized my documents in the order I'd use them, reviewed my notes one final time. Nathan arrived with Douglas Mercer and a young associate I didn't recognize. He saw me at the table and said something to his attorney. They both smiled. His mother his mother came in and sat in the gallery. She'd never liked me, even after everything I'd done during her recovery. She folded her hands in her lap and looked straight ahead. Also in the gallery, Stephanie, my replacement. She sat 3 rows back, dressed like she was attending a garden party. She caught my eye and didn't look away. I looked away first. Not because I was intimidated. Because she wasn't worth my attention today. Judge Elaine Hartwell entered at 9:02. She was 61 years old, had been on the Davidson County bench for 14 years, and had a reputation for not tolerating wasted time. I knew this because I had researched her thoroughly. I had read every published decision of hers I could access. I knew how she thought. We're here in the matter of Voss versus Voss, she said, settling in. She glanced at the respondent's table. Is the respondent representing herself? Yes, Your Honor. She looked at me for a moment, not dismissively, not with pity, just evenly. You understand you have the right to counsel? I do, Your Honor. I've chosen to proceed pro se. From the petitioner's table, I heard Douglas Mercer exhale through his nose, a small, satisfied sound. Judge Hartwell looked at him briefly, then back at me. Very well. Let's proceed. Douglas Mercer opened with confidence, the way expensive attorneys always do. He laid out Nathan's position methodically, that the marriage had been a partnership of unequal contribution, that I had voluntarily left the workforce, that the proposed settlement was more than generous given the circumstances. He used words like equitable and reasonable and realistic expectations. He was polished. He was prepared. He was also, I knew, sitting on a problem. When it was my turn, I stood up slowly. I smoothed my blazer. I took one breath. "Your Honor," I said, "I'd like to begin by entering into evidence a set of financial records obtained during the disclosure process, cross-referenced with 3 years of business filings for Voss Outdoor Services, LLC. I heard the shift in the room before I saw it. A rustle. A stillness. I laid out the documents one by one. Quarterly income reports. Bank statements. Transfer records to a holding company registered in Delaware, an LLC I had spent 4 weeks tracing back, very carefully, to a shell entity that existed, as far as I could tell, for one purpose, to reduce the apparent value of Nathan's business on paper during a period that happened to coincide, almost exactly, with when he first consulted his divorce attorney. 14 months of asset concealment. Methodical. Probably smart enough to fool most people. Not someone who had spent 3 years at a civil litigation firm learning exactly how people tried to hide money. "These transfers," I said, addressing the judge directly, "total approximately $212,000 over the course of 14 months. I have the corresponding bank records, the LLC registration documents, and 3 expert affidavits from a forensic accountant who reviewed the full paper trail." The room was very quiet. I heard Douglas Mercer whisper something. I didn't look at him. "Furthermore," I continued, "I'd like to address the valuation of the marital home, the imputed value of 18 months of unpaid caregiving services I provided to my husband's mother during her post-surgical recovery, and the question of whether the proposed settlement of $8,000 reflects any reasonable interpretation of equitable division under Tennessee Code annotated 36-4-121. Judge Hartwell was reading through the documents I'd submitted. She turned a page, then another. Her expression didn't change, but she slowed down. I sat down. From Nathan's side of the room, I heard nothing. Not the exhale through the nose, not the whisper, not the confident shuffle of a man who had rehearsed his smile. The recess lasted 35 minutes. I sat at my table and drank water and didn't look at the gallery. I heard the door open and close several times. I heard Nathan's voice, low and urgent, and Douglas Mercer's voice, no longer smooth. I didn't turn around. When Judge Hartwell returned, she looked at Douglas Mercer. "Counsel," she said, "would your client like to request a continuance to obtain additional financial documentation?" It was a generous offer, a face-saving offer. The kind of thing a judge gives you when the alternative is worse. Nathan leaned over to his attorney. I heard him say quietly, "What does that mean?" Douglas Mercer didn't answer him. He stood up. "Your Honor, the petitioner would like to request a brief continuance." "Granted. 2 weeks." She set down her pen. "I'd also like to note for the record that the court takes the matter of financial disclosure very seriously. All parties are expected to comply fully with disclosure requirements. Counsel, please ensure your client understands the consequences of incomplete disclosure." She said it plainly, no drama. Just a warning that landed in the room like something heavy dropped from a height. From somewhere in the gallery I heard a sound, almost a gasp, quickly swallowed. I still didn't look back. 2 weeks later, Nathan's attorney called Jonah. Because I had listed Jonah as my contact for settlement discussions, one small strategic decision that turned out to matter, and proposed a new settlement. The house. Full equity. No buyout, no split. The house, which had appreciated to a value of $640,000, was to be transferred to me. A share of the business income, structured as a 5-year payment, totaling $180,000. Full reimbursement for the caregiving period valued by the forensic accountant at $44,000. No mention of the $8,000. No mention of the civic. No mention of fare. Jonah called me while I was at the kitchen table of my East Nashville apartment. eating store-brand cereal, wearing a sweatshirt I'd had since college. They moved, he said. How much? He told me. I put my spoon down. I stared at the bowl for a moment. Outside my window, a bird was doing something very loud and very cheerful in a tree I couldn't see. Lenora, Jonah said, you want to accept? I thought about the morning Nathan slid the envelope across the kitchen island. The practiced smile, the word transparent, the way Stephanie sat in the gallery like she was already decorating the house in her head. I thought about my mother's coffee mug, sitting on the windowsill of a kitchen that was no longer mine. Counter, I said. With what? I told him. The final settlement was signed on a Tuesday afternoon in April in an office building on Charlotte Avenue that smelled of recycled air and copy paper, and I signed my name next to Nathan's name for what I hoped would be the last time. He didn't look at me. He'd stopped looking at me sometime around the first recess. Douglas Mercer shook my hand on the way out. A brief, professional handshake, nothing like the one at the holiday party. He didn't say anything. I thought I saw something in his expression, not quite respect, not quite apology, something in between. I walked out into the afternoon. It was a bright, cool April day, the kind Nashville does better than almost anywhere, where the sky is a particular shade of blue that makes you feel like things might actually be okay. I called my sister from the parking lot. It's done, I said. She screamed so loud I had to hold the phone away from my ear, and I laughed. Actually laughed, for what felt like the first time in months, the kind that comes from somewhere real. I want to say something because I think it matters. I am not telling you this story because I think I'm exceptional. I'm not. I made mistakes in that marriage. I gave up things I shouldn't have given up, trusted things I should have questioned, stayed quiet when I should have spoken. I don't know what I was waiting for exactly. Permission, maybe, or just someone to tell me that what I'd built before Nathan was still mine, that it hadn't expired just because I'd stopped using it. It hadn't. What I learned. The only thing I'd tell anyone who's sitting where I was sitting, drinking hot coffee in a kitchen that's about to stop being theirs, is this: people will make you believe you have no options. They will be very convincing about it. They will use calm voices and professional documents and words like realistic and fair and what's best for everyone. They will count on you to believe them. Don't. Not until you've sat down, very quietly, and asked yourself what you actually know, what you actually have, what you actually are underneath every compromise you made to keep the peace. Nathan knew who I was when I was 22, before law school, before the bar exam, before any of it. He watched me change, he watched me grow, and then, somewhere along the way, he decided he knew better than I did what I was worth. He was wrong. The house closed in June. I moved in on a Saturday with my sister and 2 of her kids and Jonah's pickup truck, which smells permanently of something he refuses to explain. We ordered pizza and sat on the floor of the empty living room because I didn't have furniture yet, and my nephew fell asleep with his head on my lap. And outside the windows of my house, Nashville was doing that golden late afternoon thing where everything looks like it's worth keeping. I put my mother's coffee mug on the kitchen windowsill. It looked right there. It looked like it had always been there. I think she would have liked that. I've thought a lot about why things ended the way they did. Not just the settlement, not just the courtroom, all of it. The whole arc of those 7 years, and then the 6 weeks that undid what he thought was permanent. Here's what I keep coming back to. Nathan didn't lose because I was clever. He lost because of the choices he made, compounded quietly over years until they had no place left to go but into a courtroom and out into the open. He moved money he shouldn't have moved. He underestimated someone he should have known. He chose a shortcut that looked clean on the surface and was rotten underneath. None of that was my doing. That was all his. The consequences were just the math finally catching up. I think about that sometimes when people ask me if I feel guilty, for knowing more than he thought I knew, for keeping quiet until the right moment, for fighting back at all. And the honest answer is no. Not because I'm hard, but because guilt requires me to believe I did something wrong. I didn't hide anything. I didn't manipulate anything. I just stopped pretending that I was less than I was, which is maybe the one thing I should have stopped doing years before the envelope ever hit the kitchen island. The hardest part, if I'm being truthful, wasn't the legal work. I knew how to do the legal work. The hardest part was the moment I decided I was worth fighting for. That sounds simple. It isn't. After years of making yourself smaller to fit inside someone else's idea of who you should be, deciding to take up space again. Real space, with real stakes, is terrifying in a way I don't think I can fully explain. You've forgotten, a little, that you have the right. You start to believe the version of you that they've been selling back to you. I had to unlearn that. Sitting at a kitchen table in a one-bedroom apartment that smelled like someone else's laundry, eating cereal I'd bought on sale, building a case that no one thought I could build. That was the work underneath the work. Not the legal briefs. The decision, made again every single morning, to keep going. What I'd tell anyone standing where I was standing is this: your history belongs to you. Everything you learned, everything you built before someone convinced you to set it down, it doesn't expire. It waits. Quietly, the way anything real waits, without drama or urgency, just there whenever you're ready to pick it back up again. Nathan thought he knew exactly what I was worth. He'd made his calculations, drafted his documents, prepared his smile. He was so certain, and that certainty, that comfortable, unchecked certainty, was the thing that undid him. Not me, him. The moment you stop respecting what someone is actually capable of, you've already started losing. Jonah told me afterward that Douglas Mercer had asked about me. Who I was, where I'd come from. I don't know exactly what Jonah told him. I like to think he just said, "She was always exactly this."